Good morning and welcome. My name's Helen from Love Wimbledon Business Improvement District. I'm chairing today because Diana's unavailable to do so, so stepping in and very happy to deputise for her. This is one of Merton Chamber's fabulous Reach Out and Connect webinar series that they've been running and we've been supporting through since the beginning of COVID, trying to keep businesses up to date with the regulations and business support as much as possible. So that you are all kept well informed and know how to access the support that is available. Obviously, today is an interesting day as we find out which tier we are in, which will hopefully allow people to, retailers and hospitality to return to work next week. But one of the things that has kept businesses afloat over the past few months in particular is the furlough scheme. And you'll be aware that the current scheme came to an end, or the previous scheme came to an end on the 31st of October. And then because we were all going into national lockdown, the government changed their policy on that, which was very welcome. We are going to hear more today from Morrisons Solicitors, who have kindly stepped forward with their employment team to guide us through that. Just a few quick housekeeping rules. If I may ask you to keep yourself on mute. If you do have any questions, either put them in the chat. We will have time, hopefully, for a Q&A halfway through. So put the questions in so that we know that those are coming through if you can, but we will be able to take some questions live, hopefully, to our experts. So do come forward with those as we go through. So without further ado, I'd like to introduce Fran and Emma from Morrisons Solicitors. Morrisons are a Surrey-based firm with a significant office base in Wimbledon town centre. So we work very closely with them in the town. In fact, they have actually sponsored the lovely Christmas tree that is behind me, although that's obviously virtual. But please do go along and enjoy the Christmas tree that we have on the station forecourt today, as I say, sponsored by Morrisons Solicitors. So small plug for them and thank you for doing that. So yes, without further ado, I'd like to pass over to Francesca and Emma. And I don't know who's leading us. Sorry, it's not Emma. It's Fran.
So I'll just say one thing, we are just going to record the session so that obviously people that can't make it, so if you do have any objections or anything, please just let me know, but we will record and share the session for everyone to pick up on afterwards and for you to recap.
Great, yes, thank you for that, Carolina. I forgot that one. Great, so over to Morrisons Solicitors. Thanks,
Helen, thanks, Caroline. And yeah, Christmas tree, got to bring a little bit of Christmas spirit where we can, haven't we? So, and hello everyone, thanks for joining us. Fran and I are really pleased to be here today. It is unfortunate that many of you are likely to be familiar with the coronavirus job retention scheme or furlough scheme. But November saw some changes introduced, as Helen mentioned, and that's what we've been asked to discuss with you today. In particular, points around which staff you can furlough, the new rules to access the 80% of wages, and whether you're able to flexibly furlough. So we'll look at all of that and we'll cover a few other connected points as well. Now, in terms of which employees you can furlough, since the 1st of November 2020, you're able to furlough employees if they were on your PAYE payroll before midnight on the 30th of October 2020. You must have made a PAYE RTI submission, that's a mouthful to get, between the 20th of March and the 30th of October 2020, notifying a payment of earnings for any employee being claimed for. But unlike before, neither you nor the employee need to have used the scheme previously. And there's now no cap on the number of employees that you can furlough. And HMRC have confirmed that if an employee was on your payroll on the 23rd of September 2020 and was made redundant or stopped working for you on or after that date, then they may also qualify for the extended scheme as well if they're re-employed by you, although there's no legal obligation on you to re-employ such employees. You'll need to agree the furlough arrangements with employees, and that's usually done by way of a signed furlough agreement. That's not new. But one of the new things is that HMRC will publish details of any employers that make claims under the extended scheme starting from December. And that wasn't a feature of the original scheme, so that is something new. Of course, the level of support under the extended scheme has also changed, and I will pass over to Fran just to run through some of those changes with you now.
Hi everyone. So really what I'm looking to cover off here is some information about the sort of practical mechanism really for furlough claims. Now, I'm conscious that a lot of people will have been dealing with furlough for a while now, and therefore I'm not sort of proposing to labour these points too much on the basis that I don't want to be teaching my grandmother to suck eggs, as it were. But I think it's probably not unhelpful just to have a sort of high level overview of the process, just a bit of a reminder, and also just highlighting a few sort of general points to note. So initially, the points I'm going to sort of touch upon are sort of deciding the length of a claim period, what to include when you're calculating wages, and working out usual and furloughed hours for your employees. So as Emma mentioned, we obviously now know that the scheme's being extended until March. The government have given themselves the opportunity to review the situation in January. So we're not sure what, if any, changes they will apply to the scheme then. But for now, we seem to have a fixed period for November, December, and possibly at least some of January, where the rules are sort of known to us at the moment. So obviously, this all came in quite late in the day. The 30th of November is the last day that employers can submit or change claims for periods ending on or before the 31st of October 2020, and claims for furlough days in November 2020 must be submitted by the 14th of December 2020. So that's just some dates to note. So when you're deciding the length of your claim period, you want to start your the start date of your first claim period is the date that your first employee was furloughed. Now, claim periods starting on or after the 1st of July, which is obviously as the scheme was operating previously, must start and end within the same calendar month. And all claim periods starting on or after the 1st of July 2020 must last at least 7 days. You must claim for a period of, if you are claiming for a period of less than 7 days, you can do that, but it can only be where you're claiming for either the first or the last few days of a month. So if you were claiming for, you know, sort of the 28th, 29th of a month, and then the 1st, 2nd, 3rd, for example, then you obviously could do that, but it would still have to be, that's the rules under the new arrangements. Where you can, they generally suggest that if it's possible to, you should match your claim period to the dates that you process your payroll, just so that it makes life easier for you. You can only make one claim for any period, so you must include all your furloughed or flexibly furloughed employees in one claim, even if you pay them at different times. And if you make more than one claim, your subsequent claim cannot overlap with any other claim that you've made. And where employees have been furloughed or flexibly furloughed continuously, the claim periods must follow on from each other with no gaps in between the dates. So it must be sort of a continuous stream of claims. You can claim before, during or after you process your payroll, as long as your claim is submitted by the relevant claim deadlines. And you cannot submit your claim more than 14 days before your claim period end date. Now, the money takes about 6 days to get into your bank account, according to the guidance. So I think probably most people will be needing to make sure they've submitted their claim sort of at least a week before payday, so that the money's available, obviously, to make payments to staff. When you're claiming for employees who are flexibly furloughed, you shouldn't claim until you're sure of the exact number of hours they're going to work during the claim period. And that means that you can only claim once you've got certainty about the number of hours they're going to work. Now, I can see that might be a bit challenging as things currently stand. Obviously, if you have an employee who's paid a fixed monthly salary and you agree that they'll come in 2 days a week, that's probably relatively straightforward to do. If, however, you've got, I don't know, for example, a retail or a hospitality business, with the changing arrangements over lockdown and the tiers coming in, I can see that it actually might be quite difficult to have certainty about what you want flexibly furloughed staff to do for a bit. So that might be an area that just is a bit more challenging, and is something just to sort of bear in mind. If the pay period that you are claiming for includes days in more than 1 month, then you have to submit separate claims covering the days that fall into each month. And you have to calculate each of those claims separately, and the claim periods cannot overlap. So if you were claiming for October, you would claim for all the complete weeks in October and then make a claim for the last few days of October, for example. Then you'd make a claim for the first few days of November and all the subsequent weeks of November. So that's how that will be working in practice. When you're calculating wages, there are a few things that you need to think about. So the first thing is, if you've already claimed for an employee who was on furlough during October, and they are paid a fixed salary, which might well be the case for a lot of employees, then you'll follow the same usual wage calculation for claim periods after the 31st of October as you did before. So if you've got somebody who's just carrying on and they're paid a fixed sum, they work fixed hours, hopefully that will be a relatively straightforward calculation. The amount you should use when calculating 80% of your employees' wages for hours not worked is made up of the regular payments you're obliged to make. So these are payments that, essentially the employee would have a claim against you if they weren't paid for. So that would be their regular wages, any non-discretionary payments that they are paid for hours worked, including overtime, any non-discretionary commission payments, for example. But you can't include discretionary payments when making that calculation. So that would include anything that's not cash related. So any benefit, for example, perhaps a company car or something along those lines. And also things like tips also shouldn't be included in that calculation. The entirety of any money that's paid under the government grant must be paid to the employee in the form of cash. And where an employer provides benefits to furloughed employee through salary sacrifice schemes, or just in general, for example, you might provide, I don't know, something like private healthcare or something like that. Those benefits should be in addition to the wages that must be paid under the furlough scheme. If you do have a situation where an employee is paid non-discretionary overtime payments, then you need to consider when you're working out whether you're calculating your 80% on whether your employee has a fixed payment or a variable payment. If they have a fixed payment, but they get lots of non-discretionary overtime, then you might want to consider whether actually you need to calculate that under the more variable calculation. The national minimum wage is probably worth a very brief mention. Obviously, you do need to have an eye on the national minimum wage if you work in or you have staff who are paid at or near the national minimum or living wages. So although the national minimum wage must be paid for all hours that are worked. So if an employee works for any period of time, they must be paid at least the national minimum wage. Training counts as working for the purposes of the scheme. Furloughed workers who are not working can be paid obviously 80% of their wages, or $2,500, based upon their usual working hours, even if that would be below the appropriate minimum wage when they're furloughed. But you do just need to have one eye on the fact that if you are flexibly furloughing employees, they need to just have one eye on national minimum wage to make sure you're compliant on that front. Just touching briefly on a couple of, I suppose, slightly different points. So holiday pay being one of them. Furloughed employees do continue to accrue holiday as per their contractual entitlements. So obviously most employees will be getting at least 28 days. It's quite often bank holidays plus 20 days holiday. Often there'll be a contractual entitlement to a bit more than that, maybe 25 days plus holiday, that plus bank holidays rather. That will continue as to be accrued as usual. Employees can take holiday whilst they're on furlough, and they should be paid full pay for holiday that they take whilst on furlough. You shouldn't, however, put people on furlough just because they're on holiday. So if somebody says to you they want to take 2 weeks holiday this month, for example, or maybe next month for Christmas, you shouldn't then say, well, in that case, we'll put you on furlough for that 2 week period. The rules say that you shouldn't do that. So if you should pay, as I say, pay 100% pay for holiday that is taken. Holiday also has some slight particularities to it around if you, for example, want to ask an employee to take holiday during the furlough period. So let's say, for example, you don't want a situation where holidays accrued during quite a prolonged period of furlough, and then that person has a lot of holiday to take, and then when they come back from furlough, they've then got a whole great chunk of holiday to take. You might be wanting to require your employees to take some holiday during furlough periods, but there are notice periods and things relevant to that. So if that's something you want to do, it's worth just making sure that you have one eye on those obligations. As previously, people who are returning from sort of sick pay or periods of parental leave, maternity leave, etc., if they're being furloughed, then their pay should be based on their salary and not the sick pay or parental pay arrangements that were in place whilst they were off. There are rules about working out the employee's usual and furloughed hours. I think this is something that I'm probably not going to labour too much at this point, purely because I suspect people have been doing it up until now. It's also quite technical and there's a lot of variations on how it's calculated, and it may well be that that doesn't add a lot of value for you. But if somebody does desperately want me to go through all the permutations, I can have a quick gallop through. If anybody's got a particular query about it, perhaps we can cover it at the end. I can see there's been a particular query here about a new employee in early October. If we maybe have a look at that at the end, we can see if we can answer a specific question on a new employee. So the main difference really is whether or not you've got employees who work fixed hours or variable hours. That tends to be where the difference is, because obviously if you've got an employee who works fixed hours, it's much easier to work out what their usual hours and pay would be. If you've got employees who work very variable hours, it's a more complicated calculation. You do, obviously, there are reference periods applicable to when you are making claims for these sorts of pay. So all of those sorts of things do need to be borne in mind. One other point that I think it's worth us touching on potentially is the records that you need to keep with respect to furlough. Again, these are the same as they have been as far as I'm aware. You have to keep all records for 6 years. And the records that you need to include are the amount claimed and the claim period for each employee, the claim reference number for your records, your calculations in case HMRC need information about your claim, the usual hours worked, including any calculations that were required for each employee that's flexibly furloughed, and the actual hours worked for employees that you flexibly furloughed. So you probably just want to bear in mind that, you know, it's probably worth now getting into a routine of keeping a file for each employee for furlough, or sub file within their personnel file. And if you're doing calculations, for example, using the government calculator to work out the amounts of pay, etc., that you'd be looking at getting, then obviously you might want to print those out and keep them somewhere so that you've got them. Just to highlight the fact that, as Emma sort of briefly mentioned, the scheme had, towards the end of the sort of previous scheme, i.e. what we thought was going to be the end of the scheme at the end of October, the government contribution had reduced with respect to furlough payments. It's now gone back up to the 80%. However, it remains the case that the government will not contribute to employer national insurance contributions or pension contributions. So those still do need to be made by the employer in addition to the furlough, sums that you're receiving from the government. The government calculator is quite good, I think, in terms of providing assistance for what you need to calculate. What I would say, however, is that the guidance or the guidance that's been provided is quite clear that it is the employer's responsibility to make sure that they are paying the correct sum. So what I would say is, if you've got a more complicated situation with respect to your employees, so perhaps something that's not as straightforward, an employee who just works, you know, a fairly fixed amount, or it's fairly easy to work out what they're paid and why, then you might want to just consider getting some specialist advice from either your payroll provider or accountant, who might be able to assist with slightly more complex elements of that. So I think I will leave it there in terms of the overall calculations about the scheme itself. I'm conscious that we might have some specific questions, and we could perhaps look at dealing with those at the end. Now, I think Emma is going to talk a little bit about flexible furlough arrangements and how they can be used.
Yeah, absolutely. Thanks, Fran. Yeah, I mean, Fran's alluded to it as well throughout her talk. So employees under the scheme can still be fully furloughed or flexibly furloughed. So it may be that you're not in a position to provide them with work now, depending on your particular circumstances. But if you want to make use of the furlough scheme in the coming months, perhaps when we're out of lockdown, fingers crossed for the announcements today. But the advantage is that flexible furlough agreements can last any amount of time. So there's no requirement for an employee to work a minimum number of their usual hours. And employees can enter into flexible furlough agreements more than once. So it is possible for you, with the agreement of the employee, to change your working arrangement from week to week, say, if needed. And there's various different options that people have been using when they're using the flexible furlough. So some people have been using a rotating furlough system. And of course, the advantage of that is that it gives everybody the opportunity to have some full paid work. And also, you know, people are using it to try and avoid risk as well. So if you've got some employees in pool A and then some employees in pool B, and they're rotating on, if someone in pool A comes down with coronavirus and as a result pool A has to self-isolate, then you've still got pool B to step in and take over that work that you need. So that's one advantage. Other people have sought volunteers to see who wants to stay on furlough, who needs to come back. So that can work around their own arrangements as well, which can make everyone a little bit more happy, and it can come to some sort of easy arrangement. Other employers have had to select who they need, though. So you might need so many numbers of managers available, or so many numbers of admin staff available. All are possibilities. You just have to ensure that when you're applying a selection process, it's fair. You're not using any discriminatory criteria unless they're justified. So sometimes people look at the shielding, or what were the shielding criteria, and perhaps the fact that people over the age of 70 are more at risk. And so they'll try and identify if they could furlough them as an initiative, which potentially could be age discrimination, but you might be able to justify it on a health and safety aspect. So all of those things that you need to consider, but it also means that you can identify what your business needs are at a particular time, and which staff you may need. I'm sure if you've had employees on furlough before, then I'm sure you'll be used to furlough agreements. You can build flexibility for yourselves into those agreements. So for example, if you need to require, or you want to have the right to require people to come back to work at a particular point, then you can try and build this into the wording of the agreements as you agree them with the employees. Now, one thing we are asked in connection with furlough quite a bit is if it gets to the point where you need to make redundancies. And I do always say when I speak to employers that, particularly as this extended coronavirus scheme has been announced, there's been a real emphasis on the fact that the idea behind it is to retain your workforce. So if you were to immediately put all of your workforce on furlough and then start making them redundant just to make as many savings as possible, then it might be that your use of the scheme in that way is open to scrutiny. by HMRC, and the government have reserved the rights to review all claims paid out under the scheme. So you just need to be mindful of that. But I do appreciate that there may be occasions where you just can't avoid redundancies. And if that is the case, then you'll need to look at the numbers that are affected, because if you've got over 20 or more employees that are at risk of redundancy within a 90-day period, then collective consultation obligations can apply, and that puts additional obligations on you. I won't go into all of those details today, but if you do want to discuss it, then obviously feel free to put a question in the chat, and I'll cover that in more detail. There's no set redundancy process unless you've got a contractual process in either your contract or perhaps even your policies. So it's always worth checking those. But generally, it's going to involve, warning your employees, consulting with them, thinking about the pooling, who's at risk in that pool, and then applying a fair selection criteria and considering alternative to redundancies. You can also ask for volunteers for redundancy as well. I mean, Fran and I are finding at the moment that a lot of employees are really, really fighting redundancy where they might not. Understandably, losing your job at this time is a particularly anxious period, but it doesn't stop you from asking if anybody wants to volunteer for redundancies. Now, there's a couple of points that we would cover in relation to additional elements that you need to consider when looking at redundancies in a furlough situation. And the first relates to pooling. Now, we're often asked about this, and apologies, Henry, I think you might have been on my talk yesterday and you've probably heard some of this, but whether you've got some employees pooling and some not, that shouldn't affect your identification process of the selection pools. It's normally the case. So redundancy applies in situations where you've got a workplace closure, a business closure, or a diminished requirement. And when you've got that, you'll need to look at the type of work which is ceasing or diminishing, and then which employees perform that kind of work. Now, if you were just to confine your selection process to those that were already furloughed, then it could be unfair, because it may be that the process that you use to identify who should be furloughed was not as vigorous as perhaps you might use when you're selecting people for redundancy. It might be that people volunteered to go on furlough, but they wouldn't volunteer to be made redundant. So don't limit it to just those people on furlough and assume that they're the ones that then would be made redundant. You need to look at the whole pool of people carrying out similar type of work and start your process from there. The other question we get asked is whether it will be an unfair dismissal if you make someone redundant rather than placing them on furlough. I mean, unfortunately, there's not a categorical answer to that, because the answer is it depends, which I know is incredibly frustrating, but it will depend on your size, your resources, perhaps your financial position. So for example, although the scheme has now been extended through to March, you have been asked to contribute since August. And it may just be that it's simply not viable for you to continue doing that, particularly if your income continues to be hit. And there may also be other reasons why furlough isn't suitable. For example, the business may have evolved in such a way that those roles just aren't needed anymore. You've changed the way the business is going to work moving forward. Or it may be that you're closing one of your premises permanently and then furlough is just not really viable. So when a redundancy situation exists, the option to furlough employees will not mean that the dismissal is unfair if you choose not to furlough them. And even the fact that there might be a possibility that you may need some of the similar roles in the future doesn't mean that you necessarily have to continue furloughing them. You just need to be able to show that you've considered furloughing as an alternative, and that you set out clearly and can explain why furloughing isn't suitable in the particular circumstances. And employees are really alive to this point, so they will very likely raise it as a reason why they think redundancy should be avoided. So there's no point in ignoring it. You'll need to address it. So you've got flexibility there in the fact that you can have employees furloughed, part-time, full-time, rotating, on ad hoc basis, week by week as needed. And then if it gets to the point where you've got redundancy, there are options available for you there as well. So, I mean, I'm going to stop talking there, although one final point I would just touch upon before we go to questions is about the job support scheme, or the JSS. Now, that was due to come into play from November when we thought the furlough scheme was going to end. But since the extended furlough scheme has been announced, the JSS has been withdrawn. We don't know if it will be reintroduced at the moment. It might depend as well on the government's reassessment of everything in January. As Fran said, seeing where we stand with everything, and then what continued support there would be beyond that. But that's not in play currently.
Can I just add in as well, just one final point, just leading on from your redundancy sort of discussion, Emma, that one other change that has occurred recently with respect to the furlough scheme is that it did used to be possible to have people on furlough during their notice period and continue to claim for that. So, you know, if you made somebody redundant and they had a 1 or 3 months notice period or something, you could basically keep them on furlough for that period and continue to claim. That is no longer possible with effect from the 1st of December. So you can no longer claim furlough for employees that are serving out a period of notice, and that's statutory and contractual notice. So that's a shift that has been put in place by the government on this occasion. So just to flag that as something that people perhaps need to be aware of.
No, yeah, absolutely. That's a very good point. Actually, there's been a lot of discussion around that point because it's felt that perhaps the contractual arrangement with people agreeing to be on furlough is different to the employer's ability to reclaim under the scheme. So although you can't reclaim for notice period, we have had people ask if we can continue to keep people on furlough, i.e. we don't want them in and they want to work out the notice, can we keep them on furlough? It hasn't been tested in the court, but there is not an express provision in the directions or the guidance that we've seen that would prevent you from doing that. So effectively like a garden leave provision, but around your furlough agreement. So as I say, it's not been tested, but it's something worth keeping in mind. I mean, it may be that you rely on other provisions in your contract anyway, if you know, you're going to make a pile-on instead, or if perhaps you'll agree to release the employee early because they've got another job to go to. But again, that's just something to consider if you need to keep your options open.
Great. Well, thank you, Emma and Fran. I mean, my golly, it's don't make it simple, do they? I have one other question actually before we pass it over to the floor, and thank you, Henry, for your first question. And please, other attendees, do get your questions in because now's your chance to iron out all your little wrinkles. There was also, from our perspective, a bonus that was available in January from the original furlough scheme that was going to be payable in January for employees that were still on your payroll in January that you had previously furloughed. Sorry, I'm probably not explaining that terribly well.
No, I'm aware of that. I don't think that applies anymore. Is that right?
No, I've heard.
They've done away with that.
Right. Okay. So for those that were thinking that you were going to receive £1,000 in January for every employee that you put on furlough between April and June, July time, that doesn't apply anymore. So be aware of that too. Great. Okay. So Henry, you put your question in the chat there, but do you want to come on and explain it in person, and then you can have a conversation?
Well, I think it's in the chat. That sort of covers it all.
Yeah.
Whenever I originally employed the employee, I explained that I had no idea what hours that she could, that the employee could be offered, because it was such a changing field. Yeah. And we were expecting that employee to be able to work 2 or 3 days every week, but as I say, to cover sicknesses and holidays, we were able to offer her full-time employment during the month of October when she worked. But and you know, and we paid her accordingly. So but she didn't work at all in November because she was furloughed.
Yes, because of the lockdown.
What do I play and what do I pay her? What do I claim?
I'll have a look into it for you, and I can come back to you with a specific answer.
Thank you.
Because it's because they're such a new employee, there'll obviously be that there should be some provision in the guidance for it. So I'll have a look and come back to you.
Thank you.
Thank you very much, Fran. Excellent. So are there any other questions from any of the other attendees on the call today? Want to put your hands up, or sorry, I haven't got everybody's camera, so I can't gain eye contact with anybody, as it were.
Hi there, it's Seamus here. No questions. Very interesting. My purpose was to we're always trying to understand how furlough is obviously affecting different businesses in different ways, because that affects how we're dealing with customers as well. So that was the purpose of my call. So it's very interesting to see what's going on and how it's affecting people in the Merton area. So thanks for that, Francesca and Emma, but nothing in particular to add to that.
Okay, great. Okay. We've got a couple of other people on the call, so as I say, do let us know if you've got any chats. Paul has come on actually with a question about, has there been any guidance regarding furloughing employees employed under the Kickstart or trainee schemes? It's something that's not directly affecting them at the moment, but may become an issue in the future.
I have to say, it's not an area that I have specifically had to deal with. So I haven't seen any specific guidance on it. I don't know if you have, Emma, at the moment. But I mean, it's something we could do a quick. I mean, in terms of pay, the note here says under apprenticeship levy, you should continue to pay apprenticeship levies as usual. Grants from the job retention scheme do not cover the apprenticeship levy. So that's what they've said in terms of apprenticeship arrangements, but I'm not aware of the Kickstart. I haven't seen anything specific to the Kickstart scheme. I don't know if you have, Emma.
No, I mean, it might be that they haven't separated that out yet, and they would just fall under the normal eligibility requirements, but it's certainly something that we can look into.
Okay, great.
I'll tell you a question that I've had a lot, and I wonder if this applies to any of you. Have any of you had employees working at home during lockdown 1 and lockdown 2, and then perhaps they're thinking about making that more permanent arrangement going forward? We get that quite a bit. Does that apply to anyone?
I think that's actually an interesting thing. We were looking at, from our point of view, we're virtually all working at home anyway, always have been. With what we do, it's quite easy. So we actually are looking at going forward, what is the future of the business in home workers, and I think one of the bigger issues we were looking at is how it affects things like how we're contracted. You know, we've all been contracted in different ways. People fell into lockdown almost. You know, they fell into, okay, it'll last a month. Let's see how we get on for a month, 2 months, 3 months. It's just gone on, and now we're in this situation where I think, you know, it's safe to say it's going to change the way we work for the next 10 years even. You know, it's not just about where we currently are. People are finding that, I mean, obviously depending on the role, we're not saying every job can be working from home, but if you've got the ability to work from home now, most people now realise and accept they've got the tools. Most businesses are accepting they can get most of their work done. You know, there are things that need ironing out. No one's saying it's perfect. But we are seeing from our customers that majority of them are not looking at offices going forward, or certainly to a lesser extent. And it's something we're examining as a business with other businesses in an online event next week. So yeah, that definitely something of interest to understand what you say about that.
Yeah, I mean, you're not alone in thinking it, to be honest. I mean, I think it's quite a common view that the legacy of 2020 might be the greater uptake of agile and home working on a more permanent basis. And there can be many benefits. A lot of we do have people saying, keeping in mind that where people are working at home permanently and all the time, they become quite isolated. And so actually maybe there is some benefit to having some face-to-face contact when, you know, when we're allowed again. But there's quite a few things. Look, obviously we can go into home working quite quickly. That we proved that when we had to all of a sudden scramble to get everything sorted for lockdown 1 and then again for lockdown 2. But where you're doing it on a more permanent basis, there are some things to consider from a practical perspective. So one might be your contract terms, and whether any of those contract terms need amending. So for example, you'll have a place of work clause in your contract. Now it might seem easy and you just replace that with insert home address, you know, and then that becomes your new place of work. But you might want to think about whether you want to reserve the right to require them to attend the office or a premises at certain times. So maybe that's for client meetings, or perhaps if you've got large scale training undertaking. So you're building that into the contract. Also, the hours of work, are they still going to be required to do the strict office hours, or is there going to be core hours, and then you're going to provide people with some flexibility around that? And around taking breaks, you're not going to have people there to oversee what breaks they're taking. So although the onus is on the employer to tell employees what those legal breaks are, you might then want to build something into the contract to say, but it's then their responsibility to take those legal breaks because there's no one there to oversee. You know, are your rules around expenses going to change? Because then suddenly they can reclaim to travel into the office because that's not their normal place of work. Do you want to have the right to enter into their property if you need to install some equipment, for example, or service or maintain it? Do we need to build that into the contract? So actually, there's quite a bit that would be worth looking at the contract and saying, do we need to update this really? And other things as well around, you know, what measures do we have in place to protect confidential information? Are people going to have that confidential information at home in hard copy, or is it all going to be on a system that they can only get to? How is that going to work? Health and safety implications as well. You'll need to make sure that you carry out a risk assessment of their working stations, for example. Now, if the employees want to work at home, they'll probably cooperate with you to identify what your working space is, whether that's by video call or whether you go into their property. That's going to all depend on practicalities. And then you might need to think about, is there any special equipment that we need to provide? Now, there's no legal obligation on an employer to provide equipment just because someone's a home worker. You will have other duties that you'll need to comply with. So if one of your home workers is disabled, for example, then providing special equipment or reimbursing them for that so that they can work at home might be a reasonable adjustment. But a lot of employers will want the employees to use their own equipment, the company's equipment, sorry, because then the company can ensure that it's compatible with their systems, that it's got all the right virus protection on it and all the security measures. So if you're going to do that, who's responsible for the cost and the maintenance and the service and building that into the contract? And thinking about, do we need to provide certain equipment in order that they can keep up the service levels that we're used to providing? So, you know, have they got access to high-speed internet? Or is it going to be the case that all of a sudden they're much slower at responding because they've got slow broadband? So do you need to step in and help them with that? Do they have a phone with an answer phone function so that people can leave messages if they can't get hold of them? So that, you know, there's all those types of things to consider. And then also from the company's perspective, if you've got insurance in place and you've suddenly got a load of home workers, you might need to look at your insurance policy to see if you need to update your provider that you've got home workers. Maybe that will affect your premiums. And is that practical? Can you afford that at a time like this? And then thinking about things like management and supervision of people when they're all working remotely and how you might monitor that work, and whether you're going to look at computer usage or screen time, and whether your data protection policies, for example, cover those details, or whether you need to update your policies in light of that. So there's a lot to consider when you're making home working a more permanent fixture. And it might be, although everybody's been doing it, but where you're thinking about making it more permanent, whether you offer it on a trial basis to see if that's going to work and you can put all those practical arrangements in place. Because people during lockdown have been, you know, we've got much better and we've been in lockdown so long now that people are used to it. But there was very much a sort of, oh, it's temporary, so I can make do with this for now. Whereas if it's going to be more permanent, it might be that you want to offer it on a trial basis with the right to revert to the previous agreement if it's not working out, and perhaps putting a policy in place, a dedicated policy, which sets out all these types of things so everyone knows where they stand. So it's entirely possible, but actually when you think about it, there's quite a lot to think about that perhaps we didn't when we went into lockdown, because there's a difference between permanent and temporary. So I know that's sort of a lot to consider, but it's certainly talking points, especially when you're talking to your clients as well, about it's not as easy as just saying, oh yeah, carry on as you are. There's quite a lot that you might need to put in place.
Yeah, I mean, when we've looked at this, we're looking at an online event next week, and we're looking at the HR side, because there's a lot of other HR areas there. We're looking at some areas around the soft side. So we've got a guy who specialised in, he's been involved heavily in addiction, actually gaming addiction, would you believe? But people who are playing online games for sort of 20 hours a day and how that affects the mind. And he's actually talking a little bit about that around this whole idea of we're now working in this little window. You know, I don't know about you, but it's you know, we go from Zoom call to another call to another call. It's just constant. And so it's looking at lots of different aspects of it, and the whole legal side, I think, is definitely a part of it that we need going on. So I may come back to you on that if I can, Emma, just sort of going forward. But no, that's you know, it's one of those things we found talking to our customers and talking to friends and colleagues. It just seems to be we have fallen into this. You know, we've fallen in, and no one's really thought about, okay, this is going to be more permanent. I mean, I actually heard the phrase yesterday. I don't know whether it's a phrase too far, but they reckon it's the biggest change since the Industrial Revolution to the way businesses are working. I think that's probably a little bit too far, and if I can see where they're going on it, you know, it is a massive way people are changing the way they're working. So yeah, it's good to get the feedback. Thanks for that.
No problem at all.
Can I just pop the question about the pay period for the October new joiner? I've just had a quick look, and what they're suggesting in the guidance is that you would be looking to calculate the average number of hours worked from the 6th of April 2020 up to and including the employee's first day spent on furlough on or after the 1st of November 2020. So that's the hours that you'd be looking to calculate. So it looks as though for that employee, you'd be going back to their start date, as it were, and then calculating the average number of hours that they worked up to and including their first day on furlough after the 1st of November.
Great. Thank you for that, Henry. Hopefully that clarifies that for you.
Yes, it does. Thank you very much. Yeah.
Lovely. Great. Paul has a question. Hi, Paul. We can't hear you, Paul. Do you want to? I think I can't see you that you're muted, but no.
Type it on the chat.
I can hear you, but I can't. You obviously can't hear me.
That's all. We can hear you now.
Okay, fine. Sorry. We're planning to open a couple of venues in the new year, potentially January, ideally January, I think. If we are put into closing and lockdown again, and we need to furlough our new employees who are clearly employed after the October deadline, is there a loophole there, or are we not allowed to hire new people and then put them into the furlough scheme, or are we just dropping them off because they haven't passed their probation periods?
Good question.
I'm not aware of anything that stand under the current rules would allow anybody who was become employed after the cut-off for the current furlough scheme to then be placed onto furlough, Emma, unless you are?
No, I think that probably ties in with the reasoning for the scheme as well. So as I said, when they extended the scheme, they really emphasised that this was about retaining workforce. So I think then if you are in the position where you can start hiring new people, it's hoped that you've taken that into consideration before. So yeah, I would have thought my thinking would be in line with Fran's as well, I'm afraid, on that.
So if they encourage us to open a venue and we open and then they tell us that we have to close, then regrettably none of those employees are protected.
Well, having said that, I mean, they are reviewing the position in January, aren't they?
Yeah.
So, and you would hope that, oh, so I can see Fran's really keen to say something, so I will let her jump in a minute.
Says under the old job support scheme, which is now sort of shelved, they did have this job this open and closed arrangement, whereby if you were forced to close as a result of government restrictions, there was a higher level of support than if you weren't forced to close under the restrictions. So I can see that there being a possibility that if in January they change the rules to something more akin to that, there might be something there. But I still don't know if that would mean that if you take on people in January, they would be covered. I suspect from a policy perspective, they might be seeking to avoid a situation where people take people on to immediately put them onto furlough, because I suspect they would have concerns about how how that might be used generally. So I can see that might still be an issue. But I think the difficulty with this is obviously at the moment is it's a very much a movable feast, and things are happening at quite short notice. I mean, obviously we didn't know that the job. I mean, just as an example, I wrote an article on the job support scheme, which we were looking to get published, and then I wrote the article, then they changed the rules on the job support scheme, so I rewrote the article, and then we were just about to publish it, and then they said, actually, we're not going to do the job support scheme anymore, we're going to extend the furlough scheme, which obviously they did about 2 or 3, very close to the end of the month. Really, there was almost no time at all. So really, I think it's unfortunate that we probably can't give a definite answer, but I'd say on the basis of the guidance at the moment, there's nothing that would permit you to do it. So I think something would change in the guidance to allow it specifically.
Having said that, when they do, so for example, when they announced this extension, they changed it to those people that were on the payroll to the 30th of October. So, this going through from January into March is based on what we know at the moment. If because of Christmas and all the relaxation of rules around Christmas, there is perhaps another lockdown in January, as some people are predicting, and as a result, there's another lockdown, then it may be that where they say, oh, because of that extension, it's for everyone on payroll as of this date, because, that people were taking it on based on those conditions. So
they moved it the first time in March, didn't they? So
they've moved it, and they've changed the goalpost a few times. So as Fran says, we're constantly sort of having to keep updated on that.
It's a really difficult one, because at the moment, no, but it doesn't mean never. It definitely won't be possible. But what would happen, I think, is that something would have to change to the scheme as it currently stands to enable it. I don't think there's anything you could use under the scheme as it currently exists to do that, but subject to the government's frequent changes on this, might be possible in the future. Don't know.
So Paul, watch this space on that one, and I'm not aware of a date of the review in January either. They've just said January as far as I'm aware. So stay in touch with, obviously, Merton Chamber of Commerce are all over this like a rash as well. And, if there is another change, who knows, Merton Chamber might want to do another webinar with Morrisons Solicitors. I don't know. I'm inviting you back both again to continue to keep us all up to speed. I think that's been a really, really useful session and unpacked an incredibly complex and increasingly complex area, actually. So thank you ever so much, Emma and Fran, for that. Before I hand over to Caroline to sum up from Merton Chamber, I would just like to do a plug for the High Street. Please do support your local High Street. Please do support your local traders. Before you think about clicking on to do online shopping or to go onto Amazon to get something delivered within 3 hours of ordering, which I just don't understand practically how that happens, but it does. Do think about those local people that are supporting your local economy. We will need them after this is all over. So I really would encourage you to, hello. I really would encourage you to support your local high street and try and buy local wherever you can for this Christmas. Okay, over to Caroline from Merton Chamber to sum up. Thank you.
Thank you very much, everybody. Thank you very much, Emma and Francesca as well. So I think, as Helen's just alluded to, I think it would be probably quite useful to do another session in the new year when we've got a bit of an indication what the next stages are going to be, because it sounds like a movable feast as ever with all of this at the moment. So I think one of the things that Paul mentioned was the Kickstart scheme. We are a gateway for that scheme. So if you are interested on taking on a young person, we are putting forward applications. We've got through our first batch of 30, we're almost at the second batch. So if it is something you are interested in taking part on, where you take on a young person between the ages of 16 and 24 who are on the Universal Credit Scheme, please do get in touch and we can help you with that application. Or if you know of any other businesses locally that are interested. So we're covering southeast of England on that scheme, so we've got a wide spread of businesses involved. We are also offering another government-backed scheme in partnership with the London Business Hub, which is the peer network. So it's the peer-to-peer learning group that will be running from the new year in partnership with Business Plan, who'll be facilitating sessions covering a whole range of topics led by you as local businesses, what you would like to cover. So if you would like to be part of that group, you need to have 5 members of staff and been trading for a year and with a turnover of 100,000. So do get in touch about that. There continues to be events coming up, as always, with these things. We're partnering with London Chamber, who are the imports experts. It's a mouthful, isn't it? Who are doing a webinar next Thursday morning about helping businesses in the lead up to the transition period. So you can sign up via our website for that. And we fancied a bit of festive fun. So Thursday evening, 5:30, if you'd like to come and join us, we are going to have a networking session with a bit of fun, just to finish off the new year and our events programme with something a bit more relaxed and chilled and hopefully enjoyable for everybody, and to prepare for the season ahead. And then we've got our new programme of events is coming live for January. So we have got a climate action network set up for the 21st, I think that is. I can't cut off my screen with the images. So our website has, as Helen mentioned, got lots of information about the COVID updates. Obviously, Morrisons Solicitors have got information, as well as Merton Council, and they do have information on our site, and I think Love Wimbledon do too, as well as the council, about the new grant schemes as well that are available. So I can share a link with you with the webinar we held last week. We had the business rates team in, who are updating businesses about what people would be eligible to. And obviously, I'd like to thank Love Wimbledon and Morrisons Solicitors both for partnering with us today for this event. So I don't know if Helen, you want to anything else to finish off this morning, but thank you all very much for joining us. And I wish you all a very peaceful, hopefully busy for businesses, especially those in the retail and the hospitality sectors. And hopefully we'll see you around town at a social distance, of course.
Yeah, let's hope for the right result at 11:30.
Hopefully we'll be here too. I can't see, no one's going to be in one, are they?
No, that's true, absolutely.
Unless you're on an island somewhere.
Yeah. Lovely. Thanks ever so much again, everybody, and hope to see you all very soon. And stay in touch. Take care. Bye-bye.
Thank you very much.
Thank you.
Thank you.